Foakes and Beer is often regarded as picking up where Pinnel's case left off as regards to the debate about whether part payment of a debt can constitute valid consideration for a promise to discharge the entire debt. As a recap, Pinnel's case held that the mere part payment of a debt cannot in itself constitute good consideration to discharge the whole debt. However, if the part payment was accompanied by some other benefit, for instance, if it was paid earlier than the due date, or if the debtor gave the creditor something in addition to the part payment, then the promise to discharge would be binding. In Foakes and Beer, Foakes owed a debt of over £2,000 to Beer. Beer agreed with Foakes that she would not bring Foakes to court to enforce that debt if Foakes agreed to pay the principal amount owed in installments by certain dates in the future. Foakes had his lawyers draft the agreement, which also stipulated that Beer would waive any right to interest. In other words, Beer would only be entitled to the £2,000 debt and not any interest that accrued. After the agreement, the principal sum was paid by Foakes, and of course without the interest. Beer later sued Foakes for the interest on the grounds that Beer's promise not to sue Foakes was not supported by consideration. Foakes, however, argued that it was. The consideration that Foakes gave for Beer's promise not to sue was, he said, the practical benefit that Beer obtained for not having to enforce the debt by going to court. The court applied Pinnel's case and held that a promise to pay parts of the debt did not constitute valid consideration. Therefore, Beer's promise not to sue Foakes could not be binding. That being said, all of the judges in Foakes and Beer expressed their reservations as to the correctness of the Pinnel's case rule. Lord Chancellor Selborne stated that if the question be whether consideration is or is not given in a case of this kind by the debtor, here Foakes, who paid down part of the debt presently due from him for a promise by the creditor to relinquish the residue of the debt, I cannot say that I think consideration is given. Consideration is not that sort of benefit which a creditor like Beer may derive from getting payment of part of the money due to them from a debtor, but it is some kind of independent benefit, actual or contingent, of a kind which might in law be a good and valuable consideration. Here he restates the rule in Pinnel's case. However, he also held that it might be, and indeed I think it would be, an improvement in our law if a release of the whole debt on payment of any sum which the creditor might be content to receive were held to be generally binding. Here Lord Selborne doubts the correctness of the Pinnel's case rule. Lord Blackburn was a bit more emphatic in his criticism, stating that what principally weighs with me in thinking that Lord Coke in Pinnel's case made a mistake of fact is my conviction that all men of business do every day recognize and act on the ground that prompt payment of a part of their demand may be more beneficial to them than it would be to insist on their rights and enforce payment of the whole, even where the debtor is perfectly solvent and sure to pay at some point in the future. This often is so. Where the credit of the debtor is doubtful, for instance if the debtor may become insolvent, it must be more so. Similarly, Lord Fitzgerald held that I should hesitate before coming to a decision which might be a serious inroad on this long-standing rule, but I concur with my learned friend that it would have been wiser and better if the resolution in Pinnel's case had never come to. We find the law to have been accepted as stated for a great length of time, and I apprehend that it is now not within our province to overturn it. noting that at that point Pinnel's case had existed for 200 years.